Topic today, academic spin-offs, stakeholders, interests, and challenges. Before coming to the stakeholders, a recent publication has stated that there's a lack of standardized startup-friendly models like those found at leading transfer institutions abroad. So we have no standardized, harmonized model for academic spin-offs. That's a shortcoming, that's a deficit, and various institutions are working on it. Spin-offs are a nibbling treasure found, but still not lifted yet. The numbers are good, but the numbers could be much better. And among the various, and I will just briefly mention various legal instruments which exist to find appropriate solutions and to overcome conflict of interest in the relationships between an academic institution as owner or licensor and startup, small and medium enterprise, and corporates as future right holders. Focus is not so much on SMEs and corporates, just there are a couple of specific issues I'd like to mention at the end of my presentation. Here you see the latest numbers. You can see FFHG, that's Fraunhofer Gesellschaft, HGF, that's Helmholtz Gesellschaft, MPG, that's Max Planck Gesellschaft, and BGL, that's Wolfgang Gottlieb Leipzig Gesellschaft. These are the numbers of spin-offs. A spin-off is not counted at the moment when the institution or the university posts it via Facebook or on its website. It requires a spin-off based on a formal agreement. Who belongs to the network? Of course, the founders, the academic institution, maybe the chair, the institute, intermediaries, for example, the TTOs, so the tech transfer offices from universities, funders, very important, exist in HTGF, strategic investors, the SMEs, industrial partners, and not to forget, consultants. What are the interests and conflict of interest we are facing? What do the founders have? Skills, talent, enthusiasm. What do they lack? Business experience, funding. What do they have? They have available resources of the institute, and they have lengthy negotiations ahead of them, and they face possible conflict of interests with tasks at the academic institution. They are still paid by the academic institution doing research and being interested in setting up their own startup. They may approach the TTO of the academic institution and ask for support. The TTO renders excellent support. Engaged managers trying to help and trying to assist the startup in setting up the startup. But of course, they have to take the risk perspective of the right holder and their employer, which is the academic institution. What they often lack of is they don't have any data available for IP value valuation during the early stages of the business, simply because there may be no data available. So it's not that they don't have access to the databases. There just may not be any. There may not exist any data, and this issue is this difficulty is a big advantage of the investment model of the HTGF, High-Tech Gründerfonds, because HTGF does not need or does not require an IP valuation during the early stages. There is the investment model of HTGF skips the initial valuation, it does not try to calculate the inherent value of the IP, which has not proven yet. This IP valuation is simply postponed to a later stage when the startup has found a first investor. The academic institution, they are thrilled that they have a startup, but they have to ensure the institution's entitlement to use the research, to continue to use the research results. They have to be entitled to revoke the rights in case of insufficient use or no use at all. They would be happy to agree upon a secondment of their academics. They also would be interested in return of their employees, and they make resources available. What is so interesting from a legal perspective? It is interesting because it offers a wide range of topics. It is about state university acts. Does a state law entitle a university to participate in its startup? The most German Länder Hochschulgesetze do. We have public law, we have the Employee Invention Act, we have all kind of issues of labor law, foremost the university privilege. So the university would be entitled to act as an employer and to have the IP transferred to the academic institution. We have, and that's at the core of the next two slides, IP law, technology transfer, licensing, R&D agreements, and corporate law, equity deal terms, what's the stake of the academic institution. And we have issues of state aid law and competition law. What are modern instruments for licensing terms and or the share of the academic institution in a spin-off? The modern instruments and modern issues include the spin-off which the employee of the academic institution has joined, gets some right of use. That could be ownership, full ownership, or it could be a license. Of course, the startup will not have any funds available in the early stages to pay any royalty fees or to even acquire all rights to the IP. So what is usually done, we agree on a waiver or a deferral of the license fees. One calls this a backloaded license until certain milestones are reached. And the university, the academic institution has to, as mentioned before, has to make sure that it can revoke the license in case of no use at all. Maybe the startup gives up the idea of incorporating a startup and starting its own business. So that's one issue. And the second issue is we've been seeing in the last, I would say in the last 2 years, is that the academic institution participates in a virtual participation scheme. So the principle being that the academic institution receives an option for a later shareholding or immediately becomes a shareholder of the spin-off. And if it becomes a shareholder of the spin-off, we'd have to discuss which share does it get? Is it 2%, 3%? Is it 15%? Or should it be even more as in common law jurisdictions where we see, so in the United Kingdom and the United States, where we see stakes of between 20 to 50% even. These are numbers we haven't heard in Germany about. If you get an option for a later share, then the granting of the exploitation rights could replace later payments for further shares. So at a point where a financial investor or a corporate investor actually pays for further shares by means of a capital increase and pays a purchase price, the academic institution argues, we have granted the exploitation rights. That's all we have. Yeah, we will not invest any more cash. And the latest trend, as just mentioned, is the virtual participation scheme. The academic institution does not get real shares. They rather require virtual shares, like in an ESOP, an employee stock option plan, phantom shares, stock option plan. That's all the same. Virtual participation of the university, which is a somewhat neat and nice and modern modern trend. And then we have, of course, last slide, non-specific issues such as NDAs. We have the necessity to clearly coordinate patent strategies. We have to think about an organizational structure, a steering committee, how do we solve internal disputes? And we have to agree upon the allocation of IP between the institution and the company, and have to think about continued collaboration after the TOT, and probably periodically updated transfer agreements. We have to make sure that the academic institution gets reporting and audit rights. We have to make sure that academic needs are preserved, such as publication rights, secrecy obligation, and a continued right to use for your own research. And of course, we have to think about, and this issue pops up quite often, claims of patent owners not becoming a founding shareholder ultimately. That's what I wanted to say for a start. Thank you very much. Just two remarks. What I've seen in latest hardware, financing rounds, robotics, a huge interest of business angels, huge interest of business angels. We just closed a round with, I think, 10 or 12 business angels involved investing. I mean, I think it was just a 4 million round, but 10 to 12 business angels with expertise in the particular market. That I found very interesting. And all these business angels, they are not pooled. Everybody speaks for him or herself. So that's an issue for a startup starting out with 16 shareholders, 4 founders, 10 business angels, and 2 financial investors. That's an issue, but we have a huge interest. I notice a huge interest, an increasing interest of business angels in hardware investments, maybe more than in biotech. And with regard to what Marie just said, new forms of asset financing, a latest trend is venture leasing. Venture leasing is getting popular.